Now you can start, ma'am, please.
Good evening, everyone. I can't see any of you, but let me welcome you all to the lecture series for AOR examinations. And before I start, let me congratulate all of you for having the guts to take the exam, because in this profession and in the Supreme Court, it is one of the most important assets to have in your practice. So, as all of you know, that I am going to be speaking on practice and procedure, and I believe you have already had one session of a lecture prior to me. So I will. What I have done for all of you is prepared a PPT which lists out the bullet points which you probably are required to know and understand to answer all these papers. And before I start with the paper, I will start with something which is far more general, which might be something that may be useful for all your papers and not for just the paper of practice and procedure. As a feedback from the Board of Examiners, I can tell you that what vexes the examiners most is non-clarity in your answer sheets. So the most important thing while taking these exams is to make sure that you are very clear while you are answering your papers. Um, Also, these papers are not there for you to show off your knowledge, so to speak, but are there for you to score and crack the exam. Just one second. So, and speaking from my own personal experience, I can share with you that when I wrote the AOR exams, I maxed one of the papers and flunked one of the papers. And later I realized that the reason why I had flunked the paper is because I didn't know how to write the answers to that paper. And that paper was the drafting paper, which I would say is the most technical paper and requires you to have a good mastery over all the technical aspects of drafting rather than the in principle aspects of petitions. So, just to show you how you can write clear papers and to make sure that the examiners are not disappointed with your papers, the first thing that I would advise all of you is to use very simple English. Don't try to complicate the answers by introducing a very complex vocabulary. Write very simple answers, to the point answers. And writing to the point answers is also important because you will have a time constraint. And therefore, you do not want to leave out any answers because that would definitely go to reducing your marks. So, write very clear, crisp, to the point answers. And if you don't know something, it is better not to write something wrong than to write something short. So keep your answers very short. In fact, this reminds me of some of my seniors who had the experience of hearing Mr. Palkiwala argue his cases. And the common thing that everyone pointed out to me was that the artfulness of Mr. Palkiwala was that he made his submissions in extremely simple language, in extremely simple English. However, he illustrated his arguments with very apt illustrations, which would exhibit to the judges as to what would be the pitfall if a particular interpretation is adopted, and how it would subserve the objective of the provision if it were to be interpreted in the manner that he was advocating. So we need to look at the fact that we want to uh, communicate easily and with clarity. And with this, I will just start the PPT where I have listed out certain tips, or I would say in a more colloquial way, certain hacks that all of you can follow and probably be able to crack your exams much better. Um, 2 minutes, okay. So before the PPT starts, let me just tell you that what I want to convey to you, what I have done is I have made an example of one aspect and one question that you may get, which is the basic question as to what is the special leave jurisdiction of the Supreme Court. And I have tried to illustrate that what would be the best manner to answer that question, whether that question is a lengthy question bearing a large quantity of marks, or whether it is a short question which has very limited number of marks. The pattern is the same, except that you will probably need to expand on the explanation if it is a lengthy answer, but be sure to include all the aspects which I'm just going to share with you while answering your exam. Uh, Rajesh, I was just wanting to share the PPT. Can you make Chambers of Vibhadatta Makhija as also a co-panelist?
Sure, madam. In a minute now.
Yeah, there'll be a login from my chamber. Have I shared?
If you can please confirm the name by which they are
It'll
logged.
be Chambers of Vibhadatta Makhija. And I have just seen a query on the chat box. Yes, I will share a PDF format of the PPT with the examination board secretary, and you can request him to be mail it to all of you. And also, uh, what I will ask you to do is to type in your questions in the chat box, and if time allows, I will take up 3 or 4 of them, which may be beneficial for most of you. So please don't feel disappointed that I didn't pick up a particular question, but I'll be picking up questions which will have a relevance to most of you taking the papers. Started.
So we'll make him presentator.
Okay,
You can share your screen now.
you'll have to make him the presentator, my chamber.
I'm already panelist.
Yeah.
Okay.
I'm just sharing.
Now you can share, ma'am.
All right, we'll just do that. I can't see. Is the PPT visible to everyone?
Not yet, ma'am.
I should be able to see it. Yeah. See a blank thing still. Nevertheless, till the PPT comes on, let me explain the method and the hack that you need to follow to write your exams. And this is essentially to keep your examiners happy, because the biggest complaint that the examiners have is that most of the candidates do not know how to write an answer, and they lose focus, they write tangential points, and the points that need to be covered, which are actually the answer, are left out. So next slide. So I have taken the example of, say, a question which says, what is the special leave jurisdiction of the Supreme Court? Now, in this, what you need to do is you need to divide it into 4 parts. Expanded? Is it expanded? Now, every answer of yours must contain 4 parts. The first part that should be contained in your answer is what is the relevant provision with regard to the concept. So you may know everything about the jurisdiction of a special leave petition, but if you forget to just mention that that jurisdiction is under Article 136, you are not going to get your marks. So the first thing that you are required to answer is under what provision is the jurisdiction provided. And to clarify that, the Supreme Court's jurisdiction is under several in several ways that the jurisdiction is created. The first thing under which the jurisdiction is created is the Constitution. So the Constitution, if you will look at chapter 4 of the Union Judiciary, relatable to Union Judiciary, contains most of the provisions under which the Supreme Court exercises its jurisdiction. And under that, you will find that besides the establishment of the Supreme Court, it also enumerates different types of jurisdiction that Supreme Court gets. So under this, if you will see from Article 131 onwards, there are different types of jurisdictions that are created. And therefore, the first point that you need to answer in your answer is under what article is the jurisdiction created. Now, not only does the Constitution create the jurisdiction, but the jurisdiction also arises out of several statutes. So several special statutes provide for the appellate jurisdiction of the Supreme Court. So therefore, in the hierarchy of its exercising its jurisdiction, the first source of power is under the Constitution. Then comes the appellate power, which is granted under various statutes, and eventually is the inherent power of the Supreme Court to exercise its different types of jurisdiction. The second aspect that you need to emphasize on or include in your paper is what are the contents of the provision. So if you were to read Article 136, what you should do is mark out the keywords of Article 136. Once you mark out the keywords of 136, it is immaterial that you write out that this is what Article 136 says. Because if you know the keywords of Article 136, they will automatically formulate a part of your answer. So if I were just to read Article 136, it says, Article 136(1), notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any case or matter passed or made by any court or tribunal in the territory of India. So what are the key concepts? The key concepts are that there are several jurisdictions which are enumerated in the chapter, but notwithstanding that, that means the horse of those, besides all of those jurisdictions, the Supreme Court will have this extra special jurisdiction to exercise, which will be against each and every order, decree, so on, decision of any court. So the key principle of Article 136 is that this special leave jurisdiction is given to the Supreme Court, which is the apex court, the final court of determination, to see if it wants to exercise its power in which is akin to appellate power with regard to any order that may be passed by any court in the country. However, the limitation is that the Supreme Court must exercise it specially, in as much as it must exercise a discretion to take a decision whether a case is worthy for it to exercise that jurisdiction or not. And therefore, when we have the miscellaneous admission matters, it is called special leave to appeal. So as a petitioner, you are taking a special leave to appeal against a particular order against which there is probably no other remedy in law. Or even if there is any remedy in law, this is a more expedient remedy. So what are the specific features of 136? Is that it is discretionary, and there are circumstances under which the discretion is exercised or the manner in which the discretion is exercised. And there are certain circumstances in which the Supreme Court will ordinarily not exercise its jurisdiction. So you need to uh, capsulate these points, and then you will, next slide, you will then illustrate it with an illustration. And that illustration should normally come from leading cases in which the Supreme Court has either explained or laid down some principles with regard to this specific jurisdiction. So the first key point of Article 136 is that it's a completely discretionary jurisdiction. Second key point is that it can be filed against any judgment, order, etc. And third key point is, but this exercise of discretionary jurisdiction will be tempered down by limitations which are self-imposed by the Supreme Court, because there's also a value that the subordinate court decisions have. So Supreme Court will be slow to interfere with the decisions of subordinate courts until and unless it feels that it requires its consideration. So the leading cases on this are Pritam Singh, Dakeshwari, and Kunya Muhammad is the key case which I would recommend that all of you read. Now coming to what are the other jurisdictions of the Supreme Court. Now the Supreme Court exercises an exclusive original jurisdiction. Now original jurisdiction is of two types. One is the original jurisdiction to decide suits, and second is the original jurisdiction under Article 32, where you have not filed any other cases in any other courts, and you will file directly in the Supreme Court to implement and effectuate your fundamental rights. Similarly, under not similarly, but separately, under Article 131, we have the original jurisdiction of the Supreme Court, which relates to suits between two states or the union. So this jurisdiction is not available to each and every litigant. It is available only to the states because the nature of disputes are such that it is felt that the Supreme Court can have the most unbiased decision making power with regard to these suits which emanate from disputes between two states or states and the union, and that is what is the original jurisdiction. And you will find and basically in practice and procedure you are also fortified by Mr. Venkataramani's beautiful book, so all the case law is available there. But in this PPT I have just indicated the main case laws, and these are what I can say the locus classicus on these points. So you can look at these, and I encourage you to look at all the other cases also which have been decided by the courts, which you may find easily in Mr. Venkataramani's book. So then we come to the next type of jurisdiction, which is under Article 32. This again is an original jurisdiction, and as far as Article 32 is concerned, two key points to it. Firstly, that it can be exercised only to exercise your fundamental rights. It is distinct from Article 226, which is far more expansive, which also allows you to effectuate your legal and statutory rights. The Article 32 jurisdiction can be exercised only in case where there is a violation of fundamental rights. There are also certain cases where you will find where Supreme Court may have exercised its jurisdiction under Article 32, though it may strictly not be infringing a fundamental right, but that jurisdiction is exercised because it may indirectly interfere with your fundamental rights. And as a flip side of it, the Supreme Court refuses to exercise its jurisdiction under Article 32 when it finds that there is sufficient and efficacious alternate remedy, which exists in Article 226, and then relegates the parties to go back to the High Court and to file their petitions in the High Court. The other very significant point about Article 32, and this is the most significant aspect of Article 32, is that it is the heart and soul of the Indian Constitution. Now, this was a statement which was made by Dr. Ambedkar in the Constituent Assembly debates. And the reason why he made the statement is because we have the chapter on fundamental rights. However, until and unless there is a self-standing independent right for a person to go to the courts to effectuate those rights, the list of rights which may be given in the Constitution would be completely ineffective and would just be an empty letter. So Article 32 itself is a fundamental right. That is a very important aspect of Article 32. And every citizen or a person, depending on which right has been violated, can approach the Supreme Court directly if there is an infringement of his or her fundamental rights. The next and one distinct aspect of Article 32, which has developed in the Indian judicial milieu, which is separate, which is very different from other jurisdictions, Supreme Court jurisdictions, for example, the US Supreme Court is the jurisdiction of PILs because of the unique constraints or unique conditions that exist in the Indian democracy. The courts have developed the jurisdiction of public interest litigation, where the limitation of you being an affected party or being an interested party will not limit that fundamental right to be effectuated in favor of persons whose rights are being violated. And this jurisdiction, in fact, has been beautifully developed by Justice Bhagwati. And even today, from 1980s onwards, we have been seeing that this jurisdiction has become stronger, and it has, in fact, been a jurisdiction which has helped large areas of social upliftment and has brought about, in fact, great social changes in the Indian society. So, Bandhuwa Mukti Morcha is the leading case on that. And in the next slide, you can see Husainara Khatun and SP Gupta, the first judge's case, where this jurisdiction has been further developed. The next aspect of fundamental rights also is the power of the courts, the writ courts, the constitutional courts, to judicially review each and every decision. Now, there are certain statutory bars, and in fact, there are also some constitutional bars to judicial review of certain authorities, which is put beyond the purview of the courts to judicially review those decisions. And it's an aspect of separation of powers where the legislature provides that the judiciary should have an hands-off policy with regard to certain decisions of the executives, and especially the executive heads. However, in Keswanan Bharti, the Supreme Court, as you all very well know, I'm just saying this and repeating this, this is because it is the most important aspect of judicial review. The Supreme Court in its constitution bench has said that judicial review is a part of the basic feature of the constitution, which power cannot be taken away, which power cannot be amended, which power cannot be modified. And this is an inherent basic feature of the constitution, and that power cannot be taken away, though it may be limited or it may be exercised in particular situations. So the courts also have restraints, self-imposed restraints from judicially reviewing certain decisions which must have a finality. And therefore, though principally there can never be an exclusion of the power of judicially review an executive decision, however, there are certain exclusions which the court puts on itself while reviewing decisions of um, of authorities, and limits the circumstances under which the decisions are reviewed. Thus, the court may not go into the merits of the decision, but it will surely strike at a decision if it, for example, it does not meet the basic requirements of the doctrine of natural justice, if it is so unacceptable and is so prejudicial or is exercised in a malified manner. So these are the grounds on which the court will still go ahead and exercise its power of judicial review. So normally the courts will be shy of interfering with decisions of, as you can see on this slide, privileges and immunities of members of parliament, or the power of the executive, which is the governor and the president, to grant pardon, suspension, and remission, etc., of sentences. And the court will also, in its power to judicially review certain policies, not direct the courts to, not direct the legislature to enact a particular law. However, the courts can also nudge the legislature to enact particular kinds of laws, because if there is a vacuum, or if there is a desirable constitutional value that needs to be implemented, the courts can go ahead and issue, I would not say directions, but can say that the legislature must enact a law in this particular field. And we have seen that a large number of laws which have had far-reaching effects have been nudged by the Supreme Court. So the laws with regard to handcuffing, for example, or sexual offenses at workspaces, these are the leading areas where the courts have normally nudged the executive and the legislature to come up with policies and laws to address certain situations where there are no laws regulating those areas. Now, a completely separate section of jurisdiction of the Supreme Court is the appellate jurisdiction. Appellate jurisdictions arise out of two sources. The first source is the Constitution, and the second source is the statutes under which the Supreme Court is made an appellate authority against decisions of, say, the first appeal courts. Under the Constitution, you will find from Article 132 onwards, the appellate jurisdiction of Supreme Court in appeals from high courts, and there are civil appeals and criminal appeals, and there are also enlargement of jurisdiction of the Supreme Court in regard to criminal appeals. So you will anyway find these when you will go through Article 131 to 134. You will find there are these different types of appellate jurisdictions. So Article 132 relates to an appeal involving interpretation of the Constitution arising out of any proceedings in a high court, civil, criminal, or otherwise. Article 133 relates to civil appeals. 134 relates to 134. Okay, 134 is basically with regard to criminal matters, and 134A is the certificate for appeal to Supreme Court. Now, this is a provision which is not used anymore in view of Article 136. And what happens in 134, which was an old thing in the sense that when we had joined the law, and I think even before that, normally when the High Court passed a decision, a judgment, it gave a certificate as to whether that decision is appealable before the Supreme Court or not. And on the certificate coming from the High Court, the Supreme Court would assume jurisdiction for appeal and exercise its appellate jurisdiction. The next aspect of appellate jurisdiction is that of statutory appeals. Now we have several special laws which are coming up. You will find that there is an appellate jurisdiction in the CRPC itself, and all the other laws where Supreme Court is the ultimate appellate authority. Usually against the original court, a first appellate forum is provided, and thereafter only the Supreme Court is the authority which is enumerated as the appellate authority. So section 379 of CRPC provides for the appellate jurisdiction. Uh, then the Customs Act provides for the Supreme Court to be an appellate authority. So, and so does the Excise Act. One of the most important appellate jurisdictions which Supreme Court nowadays is exercising is under the Consumer Protection Act, under the Contempt of Courts Act, SEBI Act, TRI Act, and IBC, which has now become a very important appellate jurisdiction. So, under all these special laws, the Supreme Court, even if there are certain tribunals which are the appellate tribunals, against orders of appellate tribunals also, the appellate power is that of the Supreme Court, which is provided in the statute. So, if the statute provides it as an appeal, then the Supreme Court exercises its appellate jurisdiction, and you need to file an appeal in that case and not an SLP. Also, what happens is that, what we have experienced is, again, something which is not in vogue nowadays. Earlier, when a statutory appeal came against a criminal conviction, all that we had to do is to stand up and say that this is a statutory appeal in a criminal matter, and the leave would be and it would be admitted for the appeal to be heard. But now that distinction has become a little hazy, and the courts are now dealing with appellate jurisdiction in the same manner as they deal with Article 136 petitions, where they exercise their discretion more than the aspects that are required to be looked at as an appellate jurisdiction. So, but however, this distinction clearly is still maintained. And what is very important as advocates on record is to know as to what is the remedy for your client, and not to make faux pas like filing an SLP instead of a statutory appeal, and vice versa. The next jurisdiction under the Constitution that the Supreme Court has, that of the review jurisdiction. Now, in the review jurisdiction, essentially the jurisdiction is provided under Article 137. The thing that I would like to bring to your attention, which has been a trend setting in the Supreme Court, is that the review jurisdiction would be exercised in chambers and not in open court, except if you made an application for an open court hearing. However, in the case of Arif Mohammed, the Supreme Court has said that if the review involves the review of a confirmation of a death penalty, then it has to be heard in an open court before 3 judges. And that is a very valuable aspect which has now been added by the judgment, because after all, if it is a death penalty, it is the last resort for a person on a death row. And in his case, the necessity to be heard and to be heard fully becomes even more acute. And that opportunity has to be fairly granted to the convict, has to be effective. And therefore, until and unless there is an open court hearing, it is difficult for the convict to understand why his review has been dismissed or disallowed. And in view of this very important aspect of personal liberty, and there being no other method by which it can be remedied at a later point of time, the Supreme Court has held that with regard to death sentences, the hearings of the review petitions shall be in open court and will be heard by minimum 3 judges. Another jurisdiction which has been carved out by case law, by precedents of the Supreme Court, is that of the curative petition. Now, both the curative and the review jurisdiction in cases of death sentences have been necessitated because of the fact that Supreme Court happens to be the last court where the matters can be decided. And in that sense, there is a higher duty on the court to act in a fair manner, and going by the adage that justice not only has to be done but has to be seen to be done. And therefore, when the Supreme Court found that there was a scope of some error, or there was a scope where a particular party has not even been given notice to be present in the hearing, then grave injustice would ensue if that party has not been heard and a final decision by the court has been given. Thus, in this case of Rupa Ashok Hurra, Supreme Court set out certain parameters under which the curative jurisdiction could be exercised. And I will not labor over that because it is again a well-known judgment. In its concluding paragraph, it gives the parameters when curative petition can be exercised. And it also lays down the procedure which requires to be followed in filing a curative petition. It also lays down the quorum which has to be constituted to hear the curative petitions. So curative petitions is the next jurisdiction. And if you just see the next slide, the next jurisdiction is that of the contempt petition. And then basically Article 141 is a very powerful power of the Supreme Court, where every decision of the Supreme Court acts as a precedent and law. Precedent and law, two separate things. It acts as a precedent and law for all the courts in the territory of India and binds all the courts and all the parties. And therefore, any violation of that can also make you subject to the contempt jurisdiction in certain circumstances. And basically, it is also a power where the court will settle law with regard to interpretations of various aspects, various statutes, also of constitutional interpretation, and those will operate as precedents. And basically, the power is so wide. One second. The power is so wide that it will operate as law through the entire country. The next jurisdiction that is there is that of the advisory jurisdiction. Now, advisory jurisdiction is where under Article 143, where the executive may make a reference to the court to advise it on the interpretation of a particular provision or constitution. And unlike Article 141, the decision given under Article 143 is not a binding precedent. It is only persuasive. It is only advisory in its character. And therefore, those references are not decisions, but advice that are given by the Supreme Court. Then there's also a jurisdiction to transfer the cases, which you can see on the slide again. I'll be sharing these slides. I'm running a little fast so that I can take some questions after this. And there is transfer of cases. Essentially, the situation is that if there is a question of law which is pending before two high courts, and there is a common question, then those petitions can be transferred to the Supreme Court. or if there are circumstances that are prejudicial to any of the parties. In those special circumstances, the Supreme Court can transfer to another High Court or to itself. And uh, lastly, what I also want to quickly run through is the Supreme Court rules. Now, the Supreme Court rules are enacted under Article 145 of the power of the Supreme Court to regulate its own affairs. And you will find that every jurisdiction that I have spoken to about right now is also bolstered by the rules, because the rules actually flesh out the procedure that has to be adopted while exercising this jurisdiction. So essentially, and Supreme Court rules, of course, is one of the most important things for the advocates on record to know. And in fact, I would say this, that it is a kind of a registry Bible, and it can help you to minimize the number of your defects or the manner in which your petitions are drafted. And it also brings out as to what are the duties of advocates, what are the quorums of judges. These are various aspects about the rules. We had the 1966 Supreme Court rules. However, because there has been a rapid transition in filings, etc., under Justice Loda, the new set of rules came under Chief Justice Loda in 2013. And you will find I have just listed out some important provisions of these rules, which I would recommend that all of you please go through and memorize. And you will see that in part 1, order 4 relates to advocates. And please do go through this order, because you will get some question from here, some or the other question from here. So these are actually the practice guidelines. This is the paper of practice and procedure, and Supreme Court rules, in a manner to speak, are the practice guidelines of the procedure of the Supreme Court. So you will find that what is the role of the advocates is enumerated in order 4, and then you will see that under order 5, the business in chambers and and with regard to how the quorum of judges will be allocated as division benches, constitution benches, is given in order 6. And there are some not such significant or oftenly used provisions, like order 7, which relates to proceedings against minors or unsound mind, etc., persons with unsound mind. However, order 9 is important for an AOR practice, which is with regard to affidavits. Order 11 also, I would suggest, should be looked at carefully, which is notice of motion. And then I would also recommend that you look at order 15 onwards, which gives you the format of various petitions. So order 15 will give you petitions generally, and part 2 is with regard to the appellate jurisdiction and how the format of these appeals is to be made is then in part B, and so on and so forth. So I would suggest that you definitely go through the Supreme Court rules very well, because there will be at least a few questions, and if not descriptive, at least at least, what should I say, the ones with smaller marks, objective type questions, which will come. Now, another thing that I would like you people to do is also look at the question paper of, I was thinking 2012. Yes, do have a look at the question paper of 2012, because this question paper, in my viewpoint, is unique because it covers a lot of aspects, but the questions are all short questions. So if you don't want to be taken off guard, because what I would think is that you will get some descriptive questions and you will get some short questions. So if you don't want to be caught off guard with regard to the short questions, then probably it will be good for you to go through the 2012 paper, because it covers a very wide compass of all aspects of practice and procedure. And you can see, things like what are the provisions in Supreme Court which provide for appeals under Section 23 of Consumer Protection. Then it deals with how are records prepared in hearing of an appeal, are they printed? So very small questions which is directly relatable to the Supreme Court rules. So if you have read the Supreme Court rules and you have read this question paper, I think you will be able to answer the question definitely, though you may not be very well prepared with it, but to get short marks here and there, it is a very important paper to be looked at. So I think I have walked all of you through the major aspect of this paper, and I'll be happy to take some questions here. And if you will give me a minute to choose the questions. What are the questions? One second. Okay, there is a, how do I read these questions? Okay, sorry. Okay, I'm just scrolling down through this. Okay, now as far as e-filing rules are concerned, definitely they are very important for this paper, because the e-filing rules have just been put in place, and the way things are going, e-filing is here to stay. So kindly make sure that you do look at the e-filing rules. And the other question is that, are citations critical? So I would say that the year in which the case has been decided is critical. And if you have the complete citation, it would definitely add to your final assessment. So then I'm just looking. Okay, so somebody has asked me what are the 4 parts in which the question should be answered. So I will tell you very clearly. The first part is that state the provision clearly under which the out of which the question arises. That is, with regard to a question on special leave petitions, please state that the jurisdiction of Supreme Court arises out of out of Article 136 of the Constitution. And the second aspect is, and it provides for the follows. So you will then bring out the the ingredients of Article 136. So first is the name of the provision. Second is the key concepts in the provision. Third is an explanation of the principle in the provision. And lastly are the leading cases. So you have to always illustrate with a point, with an illustration, which should normally come from a case decided by the Supreme Court itself. And the other question which has come is whether you need to verbatim write the provisions. I would say no, but you must have the keywords. For example, you must have, uh, ensure that whatever is the content of the provision, those keywords are clearly reflected. You may paraphrase them in your own language, but please don't make your language very flowery. Don't make your answers very lengthy. Stick to the point, and don't try to impress the examiners, because they are very experienced themselves. And okay, so there are all these questions which have been asked with regard to, why not approach High Court first for a writ before Supreme Court. These are all very well, explained concepts. So with regard to this particular question, I will say if your jurisdiction does arise under 32 and there is been a serious infringement of your fundamental right, then it may be necessary for you to come to the Supreme Court straight instead of going to the High Court. But you can go to the High Court first to exercise that jurisdiction. So that case law you will find on alternate remedy. You please look up about that. Then someone has said, can we write in our own language? Please do write in your own language, but please do write in correct English. Because one of the things which puts off an examiner most is wrong English. I will not say bad English, but wrong English. So please do write in correct language. And so I think with regard to tips on how to write the examination, so there is one more question which says, could you tell us an indicative word count for 20 mark question and for a 10 under 10 mark question? I won't be able to tell you word count, but I can say that for a 10 mark question, you can probably write about 15 lines and multiply that by 2 if you were to write a 20 mark exam. No, poor handwriting does not carry negative marks, but it carries a negative impression. So if you don't, it's better to write short and clear rather than bad and long. So I think I have covered most of your examination questions, and I don't think I want to take any of your specific questions on the law, because that discussion can really go on. And so I wish you all the very best, and I hope all of you do very well. And I have great faith in most of you, because most of you are very serious practitioners, and I hope we have very many new advocate on record this time. So wish you all the best. Thank you all.
Thank you very much, ma'am. Thank you.